What's going on, YouTube? Listen up, young elder gang. This is Joe Blow at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. This is Young Elders Law School second day. If you haven't checked out the first day, check out the first day just below this video on the video side. Alright, let's get started. A grand jury is a group of citizens who assess evidence and determine if there is enough probable cause to try someone for a crime. They do not decide if someone is guilty or innocent. Process. Grand juries consider evidence presented by the prosecutor. They can also receive information from the court that impaneled them or from a member of the grand jury. Composition grand juries are made up of 16 to 23 randomly selected citizens. Term, grand jurors typically serve up to 18 months, but can serve up to 24 months with a judge's extension. Meetings, grand juries don't meet every day, and the number of meetings depends on the district. Eligibility, to be eligible for grand jury duty, you must be an adult over 18, just like for regular jury duty. In California, grand juries also investigate and report on the activities of local governments. They can subpoena and indict, but they don't have the power to prosecute. A grand jury is a jury, a group of citizens, empowered by law to conduct legal proceedings, investigate potential criminal conduct, and determine whether criminal charges should be brought. A grand jury may subpoena physical evidence or a person to testify. A grand jury focuses on preliminary criminal matters only, and assesses evidence presented by a prosecutor to determine whether there is probable cause to believe an individual committed a crime and should be put on trial. Prosecutors often prefer grand juries because the proceedings are secret, whereas preliminary hearings are open to the public. The rule on secrecy is meant to provide several benefits. For the accused, it protects their reputation should no charges issue. Why is the grand jury proceeding secret? New York law requires that grand jury proceedings be conducted in secret. There are three main reasons that secrecy of the grand jury is essential. Secrecy ensures full cooperation of witnesses, free of fear of public humiliation, social stigma, retaliation, or other reprisal. An indictment is a formal accusation that a person has committed a crime. In jurisdictions that use the concept of felonies, the most serious criminal offense is a felony. Jurisdictions that do not use that concept often use that of an indictable offense, an offense that requires an indictment. It's a significant step in the criminal justice system and is issued by a grand jury after they determine there's enough evidence to support the charges. An indictment is a signal to the public that there's enough evidence to charge someone with a crime. It's also a notification to the defendant of the charges against them. An indictment is required before entering criminal court because it serves as a formal charge issued by a grand jury, signifying that there is sufficient evidence to proceed with a criminal trial against an individual, essentially acting as a legal gateway to bring charges and initiate a criminal case in court. Without it, a prosecutor cannot formally pursue a conviction against someone. Grand jury reviews evidence presented by the prosecutor and decide if there is enough probable cause to issue an indictment. An indictment provides the accused with formal notice of the charges against them. Constitutional requirement. The Fifth Amendment of the U.S. Constitution generally requires an indictment for serious crimes. Securing an indictment from a grand jury is an important stage in the federal criminal justice system. Without one, prosecutors are unable to bring charges against an individual and pursue a conviction on behalf of the people. Here are some key points about indictments. How it's issued. A grand jury issues an indictment by a simple majority vote after hearing evidence and testimony from prosecutors and their chosen witnesses. When it happens, a prosecutor can seek an indictment from a grand jury or file a criminal complaint directly with the court. What it means: an indictment means the criminal case is moving toward trial and has been formally filed in a felony court. What it doesn't mean: most criminal cases don't go to trial, and most end with the defendant admitting guilt. Indictment decision. If sufficient evidence is found, the grand jury issues an indictment, which formally charges the suspect with the crime. Service of an indictment informs a defendant of the charges against him. An arrest warrant authorizes police to take him into custody. Someone who is arrested will also, at some point, be informed of the charges against him. In law, a settlement is a resolution between disputing parties about a legal case, reached either before or after court action begins. A collective settlement is a settlement of multiple similar legal cases. The term also has other meanings in the context of law. A settlement involves the at-fault party or their insurance company offering compensation to resolve the case without going to court. Settlement has multiple definitions, including a legal agreement, a transfer of funds, and a geographic area. Legal agreement. A settlement is a voluntary agreement between parties to end a dispute and dismiss any related litigation. Settlements are often negotiated with the help of attorneys or insurance adjusters, but the parties involved must ultimately approve the settlement. Settlements are usually beneficial because they can speed up the legal process and avoid ongoing legal fees. However, a settlement is a compromise, so the parties may receive less than they would have if they went to trial. Transfer of funds. In business law, a settlement is the payment, satisfaction, and closing of an account. It can also refer to the transfer of funds between a payer bank and a collecting bank to complete customer transactions. In estate planning, a settlement can refer to the gift or property that passes from a settlor to a beneficiary. It can also refer to the complete execution of an estate by the executor. In civil law, settlement refers to the legal agreement adopted by opposing parties before or during court proceedings, spelling out the negotiated terms and obligations that all will accept to officially end a dispute. Most civil cases are decided not by trial, but by settlement. You should not accept the first settlement offer without knowing key information that could affect your financial outcome. This is a significant decision as it not only provides immediate payment but also closes the door to any future incident-related claims. A complaint is a legal document that initiates a lawsuit and is the first formal action taken in a case. It's a written pleading that contains the following information: parties, the names and addresses of the plaintiff and defendant; claims, the plaintiff's claims against the defendant, including the specific law's violated facts, the facts that led to the dispute as told by the plaintiff; relief, the plaintiff's request for relief, such as money damages or an order to stop the defendant's actions; jurisdiction, an explanation of why the court has the authority to hear the case. After filing the complaint, the plaintiff must serve a copy on the defendant. The defendant must then respond with an answer. In some jurisdictions, a complaint may also be filed to start a criminal case. A criminal complaint lists the charges against the defendant and the facts surrounding them. The government, usually through a prosecutor, files the criminal complaint. A complaint is the pleading that starts a case. Essentially, a document that sets forth a jurisdictional basis for the court's power, the plaintiff's cause of action, and a demand for judicial relief. A plaintiff starts a civil action by filing a pleading called a complaint. To file a lawsuit in the United States, the plaintiff must file a complaint with the court and serve a copy of the complaint on the defendant. Draft the complaint. The complaint is a formal document that explains the plaintiff's side of the dispute. It should include the court's name, the title, complaint, a statement of jurisdiction, claims, the relief sought, and the plaintiff's signature, address, and contact information. The plaintiff can use a court form or write their own complaint. Serve the complaint. The plaintiff must deliver a copy of the complaint to the defendant. Begin the pleading stage. The complaint is the first pleading in a lawsuit, and it begins the pleading stage. Pleadings are formal documents that state the positions of each party in the dispute. Other stages of a civil lawsuit include: answer, the defendant files an answer to the complaint explaining their side of the dispute. Discovery, both parties gather information about the case through questioning, document requests, and other means. Scheduling, the judge sets a timeline for important dates and deadlines, including the trial date. Trial, the jury is selected and the trial takes place. Decision, the judge or jury makes a decision. Appeal, either party can appeal the decision. There are two types of lawsuits: civil and criminal. When someone is charged with a crime and then prosecuted by the government, this is a criminal lawsuit. So, keep in mind, every time you're in court, no matter what it is you're being sued, the government is the plaintiff, and the accused person is the defendant. The defendant's freedom is often at stake, and the government must prove guilt beyond a reasonable doubt. If found guilty, the defendant may face jail time, fines, community service, or a combination of these. The defendant is presumed innocent until proven guilty, and the state must provide a lawyer if the defendant can't afford one. Criminal cases usually begin after an arrest and an indictment hearing. Examples of crimes: murder, theft, robbery, kidnapping, rape, assault, arson, and tax evasion. The burden of proof is higher in criminal cases. Criminal cases involve actions that harm society, while civil cases involve disputes between two parties. Defendants in criminal cases have the right to an attorney, but defendants in civil cases do not. Most criminal trials are jury trials, but many civil trials are decided by a judge. Civil cases usually involve disputes between people or organizations, while criminal cases allege a violation of a criminal law. Read each case description and consider whether the information given constitutes a civil or criminal case. Civil lawsuits: this is an expansive category that includes everything from suits for things like breach of contract or personal injury, divorce proceedings, cases involving child custody, as well as lawsuits against government officials and agencies. Just about any time an individual is bringing a case involving animals, as opposed to the government bringing an animal-related suit, such as when someone is charged with animal cruelty, it's a civil suit. A civil suit is a legal dispute between two or more parties that involves a claim of civil or constitutional rights violation. The goal of a civil suit is to provide a forum for the parties to present their case to a judge or jury, who will then make a decision to resolve the dispute. The party seeking relief is called the plaintiff, and the other party is called the defendant. The plaintiff can be an individual, organization, business, or governmental body. Civil suits can involve a variety of disputes, such as breach of contract, libel or slander, or recovering damages for injuries. The process for starting a civil suit includes filing a complaint, discovery, and a potential trial. Judges may encourage the parties to settle their differences through mediation, arbitration, or other alternative dispute resolution methods. The court where a civil case is filed depends on the amount of money in dispute and other factors. For example, in California, lawsuits for $12,500 or less can be filed in small claims court, which is typically faster, less complicated, and less expensive than other options. Civil suits are different from criminal cases, which punish the wrongdoer, while civil cases aim to compensate the victim or their family. However, some acts can be both civil and criminal. Below are the general stages of a civil suit and terms often found within those stages. The plaintiff files a complaint to initiate a lawsuit. The defendant files an answer to the complaint. The judge will issue a scheduling order laying out a timeline for important dates and deadlines, including when the trial will take place. The parties engage in discovery. Motions and other pleadings may be filed. A jury is selected, then the trial takes place. A decision is given by the judge or the jury. Either party may appeal the decision, and if a party is still unhappy with the decision of the appellate court, they may ask for further appellate review. Filing the complaint is what begins a lawsuit. The complaint is the initial document filed with the court, outlining the basis of the lawsuit and the relief the plaintiff would like granted. In other words, how much money she believes the defendant owes her for the harm caused, or any other non-monetary equitable remedy the plaintiff is seeking, such as an animal being transferred to a sanctuary. Relief in a lawsuit is the assistance or redress a party seeks from a court. It's also known as a legal remedy or judicial relief. Relief can include monetary damages. Compensatory damages are intended to compensate the plaintiff for a loss or injury. Special damages are a subset of compensatory damages that represent the direct costs of the wrongdoing. Injunctions, an order from a court to stop someone from doing something. Declaratory judgment. A court determines the legal rights of the parties without awarding damages or ordering equitable relief. This can be an effective tactic for settling a case quickly. The type of relief a plaintiff seeks is called the prayer for relief or demand for relief. The plaintiff must state their claim for relief at the pleading stage of litigation. In law, relief refers to the redress or assistance that a party seeks from a court. Relief is essentially synonymous with remedy, but is sometimes meant to convey a broader concept. A remedy typically addresses clear, tangible injuries or losses. This can include monetary damages, specific performance, or injunctions. A claim for relief is a particular set of facts that one party puts forth in a pleading in court to establish that they have a right to recover against a defendant. Stating a claim for relief is a synonym for stating a cause of action. Seeking relief means a party to a settlement agreement requesting enforcement of a settlement agreement under Article 17, Paragraph 1, or invoking a settlement agreement under Article 17, Paragraph 2. The main relief rule is a legal principle that allows a lawsuit to be filed in a specific location based on the main reason the plaintiff is seeking relief, even if other claims in the lawsuit would not support that location. In law, granted means to officially accept or approve a request or motion made to the court. For example, a court may grant a new trial or permission to appeal a decision. Grant can also refer to the act of transferring or giving something to someone, with or without payment. In real estate, the person who transfers the property is called the grantor, and the recipient is called the grantee. A grant deed is a legal document that transfers ownership of real estate from the seller to the buyer. In copyright law, a grant of rights is when the copyright owner assigns all rights to a publisher or other party in exchange for payment. For example, a musician may sign a contract with a record label, granting the label the right to sell and distribute their music, the act of granting. 2. Something granted, sp. A gift, as of land or money for a particular purpose. 3. A transfer of property by deed or writing. As distinguished from a mere license, a grant passes some estate or interest, corporeal or incorporeal, in the lands, which it embraces, can only be made by an instrument in writing under seal, and is irrevocable when made, unless an express power of revocation is reserved. Equitable relief is distinguished from remedies for legal actions in that, instead of seeking merely monetary damages, the plaintiff is seeking that the court compels the defendant to perform a certain act or refrain from a certain act. Common types of equitable relief are injunctions, specific performance, or vacatur. A non-monetary equitable remedy is a legal relief that a court can grant to address a wrong or enforce a right when monetary damages are not enough. Equitable remedies are more flexible than monetary damages and are designed to provide a fair solution to a dispute. Some examples of equitable remedies include injunction, a court order that requires a party to stop or do something. For example, if a company is using a patented technology without permission, the patent owner may seek an injunction to stop the company from using the technology. Specific performance, a court order that requires a party to fulfill their obligations under a contract. For example, if a seller contracts to sell a unique item to a buyer, specific performance would direct the seller to deliver the item to the buyer. Restitution, a remedy where one party returns a benefit to the other party to avoid imposing a penalty on the breaching party. A party may seek an equitable remedy if the breaching party doesn't have enough money or assets to compensate. The party wants to stop a specific action. The party needs to rescind a contract after a breach. There is a risk of irreparable harm. Equitable remedies are alternative ways to pay for damages. They are often utilized when the breaching party does not have enough money to pay. Often, equitable damages are not available unless monetary damages are not sufficient. Some types of equitable remedies are specific performance, injunction, and restitution. A typical example of an equitable remedy is monetary loss. The party who has been wronged may receive money as compensation for their losses, even if the other party does not have enough money to pay. There are two types of remedies in contract law: equitable and legal. Pleadings are the complaint plus certain other documents filed by both the plaintiff and the defendant relating to the case. This will include the answer, which is the defendant's response to the complaint, laying out the reasons why the suit should not prevail. A pleading is a formal written statement filed in a court proceeding by a party in a lawsuit. Pleadings are one of the first stages of a lawsuit and are used to formally present the claims and defenses of each party. Pleadings are typically filed early in the trial process, usually before the judge hears the case. The plaintiff, or petitioner, usually files a complaint first, which states the cause of action. The defendant, or respondent, then files an answer to the complaint which explains their defenses and may include a counterclaim. Pleadings are different from motions, which are requests made to the judge. Pleadings are written statements, while motions are requests. Pleadings are also different from evidence, which is presented later in the lawsuit. Pleadings must be written according to the rules of civil procedure. Failing to file pleadings on time can negatively impact a case. Pleading is one of the first stages of a lawsuit. In a pleading, the parties formally submit their claims and the defenses against the opposition's claims. The parties can make specific pleas, such as a guilty plea or a not guilty plea. Common pretrial pleadings include complaint or petition or bill. Probably the most important pleading in a civil case, since by setting out the plaintiff's version of the facts and specifying the damages, it frames the issues of the case. Early on in the process, generally after the defendant files an answer, a judge will issue a scheduling order, laying out deadlines and important dates relating to the case. The scheduling order will say when briefs and other documents must be filed and will also set a date for the trial. The judge may also set out a schedule for discovery in the scheduling order. Discovery will be explained below. A scheduling order is a court-issued document that manages the progress of a case from the time it's filed until the trial begins. It's a legally binding order that outlines the steps of the case and sets deadlines for key events. A scheduling order can include deadlines for joining parties, amending pleadings, completing discovery, and filing motions, instructions for exchanging documents and presenting evidence, dates for pretrial conferences and the trial, a requirement for parties to request a court conference before moving for a discovery order. The court can issue a scheduling order on its own or at the request of either party. The parties are responsible for filing a joint proposed scheduling order signed by both parties. If a party fails to appear at a scheduling conference, is unprepared, or doesn't participate in good faith, the court can issue sanctions. These sanctions can include ordering the party to pay reasonable expenses, including attorney's fees. A scheduling order is a court order that sets out the procedures, dates, and deadlines for a case to be heard in court. It is issued by the court and requires all parties involved to comply with its requirements. Okay, that's all we have for you today, students. That's day 2. Come back to check out day 3. Be sure to take your notes and do your homework. Hit that like button and subscribe button, fam. We out. Peace.